Good morning, everyone. I am Attorney General Kris Mayes. Thank you for joining us, and I want to thank especially Dr. Jill Gibson, Dr. Schnorr, and Dr. Edwards Jackson for being here with us today. Over the last several months, I have met with dozens of emergency room doctors, nurses, pharmacists, chief medical officers to hear their concerns about Arizona's extreme medical abortion bans. And these meetings began after the Arizona Supreme Court upheld the 1864 near total abortion ban following the U.S. Supreme Court's decision in Dobbs overturning Roe v. Wade. Those seismic changes in the law and the strict abortion bans that have followed have put healthcare professionals in Arizona in impossible situations. When women had a federal constitutional right to abortion, doctors could focus on caring for their patients and what their health required. But that changed when the U.S. Supreme Court took that fundamental right away after 50 years. Now, in large part because of restrictive abortion laws like Arizona's 15-week ban, doctors have a fear of prosecution hanging over their heads. And that is chilling how common sense medicine should be practiced. That fear now very often is compelling doctors to involve lawyers in decisions that should be solely between them and their patient. As just one example, an ER doctor recently said to me, "Kris, how close to death do I have to let a woman get before I can treat her and be confident that I won't be prosecuted?" This is an outrageous position for any doctor to be in the United States of America and in Arizona. But it is the reality that many providers face on a daily basis in Arizona. I don't write the laws, but it's my job to provide guidance on what those laws mean, to eliminate unnecessary confusion, and today we are doing just that. Arizona's 15-week ban includes an exception that allows doctors to perform abortions in a medical emergency both before and after the 15-week mark. In the Attorney General's opinion issued this morning, we are providing as much clarity as possible for medical professionals about what that medical emergency exception means. This brings us to the question that was posed to me by doctors and formally by Representatives Judy Schwiebert, Stephanie Stahl-Hamilton, and Senators Christine Marsh, and Ava Birch. When does a medical emergency exist under the definition in ARS 36-230-21-7, allowing doctors to provide an abortion? The text and legal authorities are straightforward and clear about what this means. To comply with the medical emergency exception in statute, the treating physician must do two things. One, that physician must exercise clinical judgment. This involves applying personal knowledge, training, experience, and discernment to the facts in light of the patient's unique circumstances and other medically relevant conditions and considerations. And then second, the physician must determine in good faith that based on clinical judgment, either a condition so complicates the medical condition of a pregnant woman as to necessitate the immediate abortion of her pregnancy to avert her death, or a delay in providing an abortion will create serious risk of substantial and irreversible impairment of a major bodily function. Good faith means an actual and honest belief without malice or intent to deceive. Once a treating physician forms a good faith clinical judgment that one of these circumstances is satisfied, the statute allows her to perform an immediate abortion, and she need not wait for the patient to deteriorate or inch closer to death. And I think that is very important. The physician does not have to wait for the patient to get closer to death to act under one of the two conditions in the medical emergency definition in law. This clinical judgment that a medical emergency exists cannot be second-guessed after the fact and cannot be prosecuted under ARS 36-2322A or B, or any other abortion law with the same medical emergency exception, unless there is proof that the doctor acted in bad faith or acted without good faith. Big picture, it is really important to remember that in many instances where a medical emergency exists, these are very tragic circumstances, and often these are desperately wanted pregnancies where families are heartbroken to be ending the pregnancy in order to preserve the mother's health or life. And in some of those tragic cases, risk and additional heartbreak could have been avoided by allowing abortions before the medical emergency arose, but after 15 weeks. Again, I can't change the 15-week law, but I can try to provide clarity on what the medical emergency exception means so that doctors like these are not needlessly confused and patients aren't needlessly suffering and dying for lack of health care that doctors are allowed to provide. So as the top legal officer in the state, let me be perfectly clear. Arizona law does not allow for the prosecution of a treating physician who exercises their clinical judgment in good faith to provide an abortion under the medical emergency exception, full stop. And I have said before, and I'll say it again today, I will not prosecute any physician, nurse, doctor, or pharmacist under our state's abortion laws. I am making it clear to all county attorneys that the law does not allow you to prosecute medical providers acting in good faith according to their clinical judgment and providing abortion care in medical emergencies. And I would encourage all healthcare providers and their lawyers to read this opinion and determine how best to disseminate that information to instruct their doctors accordingly. I thank you in advance for doing that important work on behalf of all Arizona families.